Hey guys, so again, I want to apologize for the mix up with our um, stream this afternoon. That was an unexpected connection issue. Not sure whether it was my device or whether it was the university's network, um, but here I am at home with a more reliable connection and a less beat up uh, device. Um, so it is not going to be normal or usual for lectures to be delivered asynchronously in this class. The faculty has a policy of preferring giving you a synchronous option, and we will continue to offer that option. There may be some asynchronous lectures after my surgery next week, just because I may not be in a position to handle uh, a full lecture environment. But we're going to try and keep this sort of as normal as possible. Okay, so today, this week, right, we're going to be talking about the breach of duty analysis, right? So last week we talked about the duty of care, how the duty of care is developed, and um, we concluded that the test for the duty of care in the Caribbean and in the UK, right, is sort of we know it when we see it. Um, there's some room for judges to engage in considering policy considerations. Um, Certainly, where the duty has already been found, it continues to exist. But new duties require some sort of uh, compelling analysis. In the Caribbean, most of the cases spend a lot of time discussing whether the duty has been breached. So, whether there's a duty of care, not terribly interesting for Caribbean judges. Whether the duty has been breached is a major source of analysis. So there's lots of case law that talks about the breach of the duty, but the problem is that the case law says on lots of occasions, right, many times, that we don't really have clear principles that draw from the case law. That what we really just have are a lot of examples. And we're left going, well, the breach of the duty happened in this case, and this case is a lot like our case, and so we think that the breach of the duty happens. But there are a few things that have been drawn on in lots of cases and that we can sort of refer to as principles that animate this analysis. And the first one is that negligence is one of two things. It's either the omission of something that a reasonable person would do, or it is the commission of something that a reasonable person would not do. And this, of course, raises the question, who is the reasonable person, right? The reasonable person is the person of average intelligence and average knowledge and et cetera, et cetera, et cetera. To some extent, it depends, right? So we look at the facts of the case and the questions that we ask in determining what a reasonable person would do is we ask, okay, what would a person of average intelligence think about this situation? So we're not really concerned with whether our defendant is especially smart or especially dumb, right? We are just saying, we're going to treat you as if you're an average intelligence person. And then we ask, what would a person of average knowledge in that position know? So, for example, right, a person of average knowledge would know that it is very rare for a car to stop on a dime, right? When you put on the brakes on your car, even if you put them on as hard as you can, the car is going to continue to coast for a time. What a person of average knowledge might not know, right? What they might not know is the relationship between the clutch and the brake on a manual transmission car. Okay, they may not know that pressing the brake without pressing the clutch introduces a different set of problems. And that may be a situation where those two facts matter for a given car accident. I don't have that fact pattern sort of ready for you, but it's possible. And the third thing that the reasonable person would do, right, the third thing that defines the reasonable person is what would an average person having the skill necessary to undertake the action be able to do. So we're not asking what would the average Joe Blow off the street be able to do in this situation, but for example, if we're dealing with a car accident, what would an average driver be able to do? If we're dealing with a medical negligence case, what would an average doctor be able to do? You know, and so on and so on and so on. And there are some special cases, right? So, for example, in medical negligence cases, many times you will have expert testimony on what the duty of care is. In fact, some jurisdictions actually require you to have identified an expert prior to going to trial, right? You have to disclose to the other side who your expert will be and give the other side an opportunity to obtain their testimony. You may have a situation where the experts disagree with one another. And in that case, the court sort of has to determine whether one or the other of them has better expressed the duty of care. And there's some ways that courts go about doing that. The book mentions a couple of them in passing, but doesn't go into a lot of detail, and so neither will we. Another special case would be the duty to warn. So there may be a situation where a tradesman or a professional is being asked by a client to undertake a course of action, right? Happens to lawyers all the time. The client says, I want to do this. And it is my professional judgment or your professional judgment that the course of action the client wants to undertake is not in their interest for reasons X, Y, and Z. As a professional, I have a duty to warn the client, I do not think this is in your best interest for reasons X, Y, and Z, right? The example in the textbook is the example of the plumber who was engaged to install a water tank at a client's on a client's property. The client wanted the tank installed on a wooden stand. The plumber said, look, we can put it on a wooden stand for you, but it's going to rot. The stand's going to rot because the tank is going to leak and there's going to be water all over it, and water introduces rot, and you know, it's not going to last. The client says, do it anyway. So the plumber says, all right, builds the stand out of wood. 18 months later, it rots away and collapses. Client sues the plumber for negligence, says you shouldn't have built this with wood. The plumber goes, that's exactly what you told me to do, and I told you not to do it, and you said do it anyway, right? Court says no negligence. The duty was the duty to warn of the consequences, not to avoid them. If the client chooses the consequences, so be it. Okay? But now we come, that is helping us to define what the reasonable person is, right? So these are the things that the reasonable person would take into consideration when deciding what to do. But at that point, we have to ask ourselves, what would the reasonable person do? And this is the key piece of the breach analysis. Okay? And it asks two questions. The first question is, what did the defendant need to do to prevent the harm? And the second question is, was it reasonable for the defendant to do that under the circumstances? Okay, so the first question is a fairly straightforward question of fact. It depends on the specifics of the case. Usually the plaintiff is going to be able to say, this is what you should have done, Mr. Defendant or Miss Defendant. But the second question is more complicated, and it involves 4 inquiries into what is sometimes called the risk factor. So what are the 4 inquiries? The first inquiry has to do with the likelihood of harm. The likelihood of harm. And so what that means is that we are interested in what's the probability that anyone will be harmed by an accident resulting from the failure to do what the defendant should have done, what the reasonable person would have done. Okay? What's the likelihood of harm? If the probability that anything goes wrong and someone gets hurt is 1 in 1 million, then maybe it's not worth worrying about. But if the likelihood that someone gets hurt is 1 in 100, well, that's something that we should consider, right? Give you an example, right? Let's suppose that we have a mine operator, okay? Someone running a mining operation, an underground mining operation. And periodically the mine hits pockets of, poisonous gas that are trapped underground, and the miners need to clear out and let the gas vent to the surface before they continue opening up the mine. The mine operator can choose not to install ventilation shafts, right? Just say, no, we're not going to do it. It's an unnecessary expense. But the likelihood of harm if they don't, I mean, it's almost certain, right? Probably someone's going to die if you don't have any sort of ventilation system in your mine. Whereas, same mine, right? Same problem, same issue. Refusing to install a series of airlocks to allow the miners to isolate themselves in a safe space. The likelihood that there would be a harm from that is quite small. So we would find the failure to install the ventilation shafts to be negligent, but we might not find the failure to install airlocks to be negligent. So that's the first inquiry in the risk factor. The second inquiry is the seriousness of injury. So the worse it is that someone can get hurt in the event of an accident, the higher the defendant's duty is to prevent those accidents, right? So, for example, here's an example. What's the worst thing that can happen if you go to a bad barber? I mean, you can die, right? If you're getting a shave with a straight razor and the barber trips over his feet, he could cut your throat with it, right? And so that's why when barbers are being trained, one of the things that they learn to do is they learn how to shave balloons with the straight razor. I kid you not. This is an actual thing that barbers do. Is they take the straight razor and they shave balloons with it, and if they pop the balloon, obviously they have failed that exercise. So, um, so this is a very serious injury, and we take some serious steps to prevent it. But the likelihood of that injury is quite low. And so we don't impose a lot of demands on barbers to prevent death, but we do demand some. Whereas with physicians, whom everything they do is life or death, right, or could potentially be life or death, we impose a far higher duty of care on them and expect them to take greater care to prevent accidents. So that's the second inquiry, the seriousness of the injury. The third inquiry is the importance of the activity. And what this says is that where we find that what the defendant was doing served a social purpose, we may be willing to tolerate greater risk than if they're just out there like doing business trying to make money. Okay, and where this issue normally arises is with excessive force and negligent use of force cases against the police. So, um, if the police are, pursuing a criminal and they use deadly force and, you know, they make a mistake and they accidentally shoot a bystander, um, the standard of care, the duty that that is they are held to is lower, and it's easier to avoid a breach than if they're a private security guard and they shoot a trespasser. Okay? And finally, and that the last inquiry that we take in the risk factor is the cost and practicability of measures to avoid the harm. The cost and practicability of measures to avoid the harm. So then we ask, what is it that the defendant would have to do to avoid this harm? And is it reasonable to ask that of the defendant? So, for example, right, to work through the three examples that we had earlier, um, with the likelihood of harm, okay, we, oh my gosh, I'm blanking on what the example was. For the likelihood of harm, we discussed, well, we'll use a different example, right? Um, we, if you look at the um, prescription of thalidomide to uh, to women. Okay, thalidomide was a wonderful anti-nausea drug that was almost certain to cause children to be born with no limbs, which means that when a doctor uh, prescribed it, he needed to ask, are you pregnant or could you become pregnant? And if the answer is yes, he needed to not prescribe it. And avoiding this was incredibly simple. Incredibly simple. Don't prescribe the drug. Take 5 minutes to read one of the many research studies that disclosed the risks of thalidomide to unborn children. The second example that we used was the barber, right? And the seriousness of the harm, right? We talked about uh, the training shaving on a balloon, and the fact that once that they receive a lot of training to prevent them from accidentally cutting a customer's throat, but they don't necessarily receive a lot of training on providing, good looking haircuts, because the harm that ensues from that is very low. Okay, they get some because nobody wants to look bad, but they don't. Anyway, I'm not gonna. I'm digressing. And so when we look at the remediation required, right? The remediation consists of training, and it's fairly minimal training. And so without that training, we should be imposing liability, because it's not hard for a barber to learn how to not cut a throat. And finally, right, with regard to the importance of the activity, right, we talked about the use of deadly force. Okay, what's the alternative? For the police officer to, get shot themselves, be assaulted, for the criminal to get away. These aren't good alternatives, and so we should be encouraging. Well, okay, maybe we shouldn't be encouraging, but we shouldn't be imposing liability for a good faith effort to exercise police powers responsibly, whatever that means. Learned Hand summed all of this up in a very simple mathematical formula that a lot of jurisdictions have adopted and nobody seems able to figure out how to apply. But what he said is, if the benefit of any remediation is less than the liability that would be imposed, and the liability that would be imposed multiplied by the probability that that liability gets imposed, then it does not make sense to hold the defendant liable. So the break point where it makes sense to hold the defendant liable is the point where the benefit of remediation equals the cost of liability multiplied by the discount rate, right? The discount rate being the probability. Okay, I'm gonna actually post a video to eLearning that I think does a really good job of explaining this, and you guys can take a look at it. Okay, so this is the lecture for today, right? On Wednesday, we're going to talk about the duty to act, right? The positive duty to act, as opposed to simply a duty not to harm. So that's going to be negligence by omission. And then we're going to talk about res ipsa loquitur. So make sure that you've reviewed those two sections of the book. And yeah, we'll see some of you tomorrow and the rest of you Wednesday. So take care and bye.